The court calls State versus Sides 400A 19-1. Mr. Orsman.
Thank you. May it please the court, I'm Assistant Appellate Defender Wyatt Orsman, and I represent Bonnie Sides in this case. If it pleases the court, I'd like to reserve 5 minutes for rebuttal.
You may.
Thank you. After the third day of Miss Sides' 6-day trial, she went home and tried to kill herself, taking 30 times her daily dosage of Xanax. She was taken to the hospital, where she was examined by a doctor who found her to be mentally ill and believed her condition was getting worse. A magistrate agreed with these medical findings and entered a lawful order involuntarily committing Miss Sides. After she was involuntarily committed, she continued to be suicidal and had to be put on suicide watch. She reported hallucinations. Her agitation was so severe while she was committed that she had to be administered Haldol, which is a powerful antipsychotic medication, as well as a sedative and antidepressant. The trial court knew all of this and yet didn't conduct a hearing on whether Miss Sides was competent to stand trial. The trial court's failure to do so violates Miss Sides' statutory and due process rights. The Court of Appeals decision finding no error should be reversed, and Miss Sides' convictions should be vacated, and her case should be remanded for a competency hearing. A criminal's right not to be tried while incompetent is protected by statute. Section 15A-1002 clearly states that a defendant's competence can be questioned by any party and even by the trial court itself. And that's exactly what happened here. During their conversation on the record about how to proceed, the trial court asked defense counsel, "Do you know of anything prior to Miss Sides' suicide attempt and involuntary commitment?" And this is the court's words. It indicated that she lacked the competency to proceed. Its question shows that the trial court recognized that her suicide attempt and involuntary commitment suggested that she might lack the competency to proceed. And counsel's arguments also raised the question of her competency. Counsel argued that it would be a leap, those are his words, a leap for anyone other than a doctor to determine whether Miss Sides' absence from trial was really voluntary, and asked for an investigation. That argument, I believe, is sufficient to adequately or properly raise the question of Miss Sides' competence. The statute also clearly states that once the defendant's competency has been questioned, once it's been triggered, the trial court shall conduct a competency hearing. It's mandated.
Mr. Before you go any further, let me, with respect to the trial court's statement, is it your argument that the mere fact that the trial court makes a statement that suggests it's at least crossed his or her mind that competency might be an issue, that's enough to trigger the application of the statute?
I think that's the most prominent fact that suggests that that the question of her competency was lurking in the trial court's mind. But
is lurking in the trial court's mind enough to trigger the application of the statute?
I believe it is. I believe saying the words, does this defendant have the capacity to proceed? Right. I mean, that parrots the language of the statute. Does she have the capacity to proceed? I think that triggers the statute. But in addition to that statement, the trial court also made comments about, well, we need to get her medical records because things turn different. Things get different when the mental aspect is involved, right? I mean, he made several comments suggesting that the question of her competency was lurking there.
Let me ask you something about that, Mr. Orsman. Did the trial court obtain the medical records from her hospitalization after she ingested the drugs?
Yes, yes, Justice Hudson. The medical records came in two waves. Initially, all the parties had was the affidavit and petition, that normally comes with an involuntary commitment, and that came before the Memorial Day weekend, the Labor Day weekend. And then after she was committed, after the trial court entered an order requiring the disclosure of her medical records, then over the weekend, a second wave came, which is the court exhibit 3, which was submitted to the appellate division separately. And it's a separate filing. It's about 90 pages, and that's what came in over the weekend.
And did that include the discharge summary from, I guess it was from the 9th of November?
Yes. Well, I mean, it included, well, there was the discharge from the emergency department. That was her first discharge. She was then taken.
Right. That's not the one I'm talking about. I'm talking about the one after she had been admitted from the emergency department.
No,
and I guess my question is really whether if the trial court had those records at hand and they indicated some degree of an ongoing problem, was that enough to trigger the requirement of a hearing under the statute?
I think the combination of the trial court statements and defense counsel's arguments based on what we have in the medical records. I mean, I think even the prosecutor made statements about, boy, it sure would be good to have a medical professional in here telling us what these mean. It would help us make a better decision about how to proceed. I mean, there's several comments by all the parties saying, I wish we had someone that could tell us what all this meant, because this is getting complicated. And so I think a combination of all those things is sufficient to trigger the statute in this case. I don't know that this court needs to make a decision of sort of how many reeds you could pull out of the raft and have it still float. I mean, I think that the evidence here is sufficient to trigger the statutory requirement.
And at what point does the defendant contend that the competency hearing should have been held?
I think it should have been held, or at least the trial should have been continued on November 13th. That's when the trial court had the medical records. I mean, I would argue that the trial court should have requested more medical records, but so that's the moment in time when it went from, we just have the cursory involuntary commitment order and the affidavit and petition to real medical documents suggesting that much more was going on here.
So are you saying that at that point on the 13th, that the trial court should have continued the trial and determined what else it needed to collect and then held a competency hearing?
Correct, on November 13th.
Okay.
Yes.
Okay, gotcha. Thank you.
Yes.
While we're not bound by the Court of Appeals opinion in the Minyard case, Are you asking us to overrule Minyard, or are you distinguishing the present case from Minyard?
I'm asking you to overrule Minyard. It's not consistent with the Supreme Court's decision in Drope. It's not consistent with the Supreme Court's decision in Warren.
And of course, both of those are U.S. Supreme Court cases, right?
Right. Yes. So in my briefs, and I'm happy to talk about this today, I believe Minyard is bad law. I mean, it's just not consistent with Drope. It's not consistent with Pate. It's not consistent with Morin. I cite several federal district or appellate court decisions that suggest that when you have evidence of that the defendant might be incompetent, you need to determine whether they're competent first.
Drope involves some weighing factors, evidence of the defendant's irrational behavior, his demeanor at trial, prior medical opinion as to competence. How would you have this court to ascertain whether or not the weighing factors have been inappropriately weighed or balanced?
Well, I would articulate this statement as a sufficiency of the evidence standard. I mean, it's the familiar standard from a motion to dismiss for insufficient evidence, right? Whether a rational trial court, a rational fact finder could believe that she might be incompetent, and that stems largely from the Pate v. Robinson case, where the majority addressed the state court's argument that said that the defendant had voluntarily waived their right. There was no evidence or insufficient evidence of incompetence because of his alertness during certain colloquies. And the majority said, look, you can't cite some of the evidence to negate other evidence, the evidence that does suggest that there is incompetence. And I think that's even more supported if you look at Judge Harlan's dissent in Pate, because Judge Harlan brings up the balancing test. He says, yeah, there's some mild evidence of her incompetence, but I think on the whole, the evidence shows that she's incompetent. But he's the dissenter. That's been rejected by the majority in Pate. So I think part of the constitutional test is the standard for reviewing the evidence. The standard for reviewing the evidence is a sufficiency. Right? Whether a rational fact finder would have a
courts around the country have differed on their approach to suicide attempts in terms of signaling incompetency. Are you asking us to announce a bright line rule that a suicide attempt in all cases categorically requires a competency?
Absolutely not. Absolutely not. This would not be the appropriate case to do that because there is more evidence. As the famous line from Drope is, the suicide attempt does not stand alone. Right? There's plenty of other evidence suggesting that she might be incompetent than the suicide attempt here. So this court is not being cornered into having to make a bright line rule.
Now, when you advocate, as you did in your brief and have here today, for the sufficiency of the evidence kind of approach, the evidence has to be even under this view. The evidence has to be sufficient to support a finding that the competence standard is not met. Right?
Correct.
I mean, we're talking about sufficiency of the evidence, and I can't rattle it off very well, but we're talking about sufficiency of the evidence to show that the person doesn't understand what's going on and can't work with their counsel.
Right. Doesn't have a.
In essence, it's phrased better by others, but that's the guts of it, I think.
Right. Right. Has a factual understanding of the proceedings, can assist with her attorney. So
you're not advocating that simply because the record shows that someone has a mental disturbance of some nature they're therefore incompetent, that the sum total of the relevant conditions suggest that there's a basis for believing that the defendant could not comprehend the nature of the proceedings and assist in the defense.
That's correct. Right. I think it's pretty clear from the case law that just mental illness alone is not sufficient.
Is involuntary commitment sufficient?
I think that would. I mean, here, I think it's strong evidence. I think when you combine it with the rest of the evidence in the record, because if you look at Chapter 122C, which defines mental illness, one of the prongs is lacks a capacity to exercise judgment, or a diminished capacity for judgment. And I think here the evidence, right, that that she's on medication, she's tried to commit suicide during the middle of her trial, and two doctors and a magistrate believe that she's mentally ill, meaning that they believe that she has a diminished capacity to exercise judgment. I think that is strong evidence that she might not be able to consult with her attorney or assist in her defense.
Around the continuum between that Minyard case, U.S. Supreme Court cases that you cite, would be our Badgett case. To the extent that there was no competency hearing requested at any time by defense counsel at the trial level, how would Badgett fit into your analysis here that there was no waiver of the right by the defendant to have a competency hearing?
I believe in Badgett, the issue of waiver was not raised by anyone at the trial court level. And here, it's at least my argument that the statements by the trial court were enough to trigger the statute, and defense counsel's statements were enough to trigger, and even comments by the prosecutor himself, combined collectively, like it all showed that this was a question.
But the fact that there was not invoked a request by the trial counsel for the defendant to have a competency hearing at any point, you don't feel as though that in any way takes the requirement of the trial court out of having to make the inquiry in light of these circumstances in this case?
Well, I believe counsel did request it. I mean, inartfully, but he said someone other than a doctor should be making a decision about whether her absence from trial is voluntary. Right? Someone other than a doctor, right? Someone other than us, a doctor should be deciding this, not two attorneys and not a judge should be deciding whether her absence from trial is voluntary. And he specifically asked, there needs to be an investigation, right? He didn't utter the magic words of, Chapter 1, 15A-102, 1002, or, capacity to proceed. But what he was asking for was an investigation into the voluntariness of her absence. I think that's good enough.
Does your personal presence claim essentially hinge on acceptance of your competence claim?
Can you say more? I'm not sure.
In essence, I mean, you've got both. Your brief talks about both of those issues. It's clear on the one hand you can't try somebody that's incompetent. On the other hand, it's also generally clear that if a person absents themselves from trial, there's a presumption that they voluntarily did so. In the event that the court was to determine, I understand you don't think we should, but in the event that the court was to determine that the information presented to the trial court was not sufficient to trigger the necessity for the competency hearing, either as a statutory or a constitutional matter, is there a personal presence claim remaining after that point?
Yes, yes, absolutely.
All right, at least as I understand it, the trial court and the Court of Appeals essentially said, first, there's no, not sufficient evidence. There was no invocation of the statutory right. There's not a sufficient showing to trigger the constitutional right.
Mhm.
Or, there's no basis for an incompetency determination. The defendant admits having voluntarily taken an overdose of the drug in question. Therefore, the defendant voluntarily absented herself from proceeding. It seems to be their logic in essence.
Right.
Assuming
Yes.
you don't have enough to get to the incompetence issue, why doesn't that logic work?
I think there's still evidence of that Miss Side's absence from trial was not voluntary. It was legally excused.
Well, and I understand the notion that generally speaking, if you're involuntarily committed, you don't have the right to pick up and go anywhere you want to. On the other hand, if you were involuntarily committed, I mean, the decision of the Court of Appeals seems to suggest that if you're involuntarily committed as the result of a voluntary action on your part, your absence continues to be voluntary. What's your argument in response to that logic?
My response is that's a dangerous misunderstanding of how mental illness works. The state picks up on the fact that she said that she committed suicide to avoid trial, or excuse me, to avoid going to jail. But that falsely equates intentionality with competence. I mean, two doctors and a magistrate found that she was mentally ill. Right? She was mentally ill. They found her to be mentally ill at the time that she was committed. Right? There is documentation showing that it was highly likely that she was going to try to commit suicide again, that her mental illness had gotten worse over the past few days, and that she needed to be immediately committed for her own safety. And I think that lawfully excuses her absence from trial. Just because she started on that course of conduct because she didn't want to go to jail, right? That's that's a false equation of competence and of intentionality. If you look at the medical literature, right? If you look at this court's prior decision in Petty, right? Mental illness can deprive a person of normal judgment, even when their conduct can be described as intentional.
So your argument is that there needed to be a competency hearing to determine whether or not she was capable of making a voluntary decision to commit suicide.
I'm sorry, I'm having difficulty hearing you. Can you repeat that?
So essentially, you're saying, I believe, that there needed to be a competency hearing to determine whether or not she was capable of making a voluntary decision like that.
Yes, right. I mean, competency has to come first. There's no way to determine whether she voluntarily waived her right to be present without first figuring out if she was competent. Right? Maybe she was, maybe she wasn't, but that's for the competency hearing.
Can I go back just to the sufficiency of the evidence standard? Because isn't the question here whether the evidence was sufficient to indicate there was a question about her competency? And then the issue of whether or not she was in fact competent is what the hearing is supposed to determine, right?
Absolutely. And I mean, I think it's important to stress the different thresholds, right? The threshold for getting a hearing is extremely low, just like in the motion to dismiss stage, right? If it's the same as should the trial court let this charge go to the jury, right? Could a rational fact finder have a question about her competency? Not is the evidence good enough to convince them? Not, beyond a reasonable doubt, none of that. It's just, could a rational fact finder view this evidence as raising a question, a bona fide doubt, a genuine doubt, right? There's no weighing of the evidence until you get to the competency hearing, right? And that's right. And the trial court is free to balance the evidence then and weigh it and do credibility determinations. But you don't do that until you get to the competency hearing.
Should we adopt your position in this case? Can you provide any guidance on how we would in turn guide trial courts where there may be a concern that in a situation like this one, a defendant is not along the way compromising or perhaps even sabotaging trial proceedings by a voluntary ingestion of substances?
Yes, I think that if the court is concerned that there might be malingering or what happened in Minyard, I mean, I think you call a continuance or stop the proceedings for a minute. You have a conversation with trial counsel, with the defendant, with the parties. Is there a history of mental illness? Is there a history of drug abuse? Is there some reason why I shouldn't think that this is, you destroying your competency through intoxication, right? I think that could be a fairly brief conversation, right? You don't have to commit them to Butner. Right, you don't have to get necessarily a medical expert, right? It can be sort of a quick and dirty examination, right? I mean, I think it needs to be sort of modulated to the facts of the case.
Mr. Orsman, you're well into your rebuttal time if you would like to reserve the rest.
Yes, thank you very much. I think if there are no other questions.
All righty. Mr. Clayton?
Thank you, Chief Justice. May it please the court, my name is Keith Clayton, Special Deputy Attorney General, and I represent the state in this case. As a threshold matter, defendant is attempting to make this case more complicated than it actually is. This case is controlled by a rule of law handed down by the Supreme Court more than 100 years ago in Diaz versus United States, that where the accused voluntarily abandons the trial after the proceedings have begun, this does not nullify the proceedings or prevent the completion of the trial, but on the contrary, operates as a waiver of the right to be present. The waiver rule set forth in Diaz reflects the public policy interest at issue here in preventing defendants from taking advantage of their own wrong. The public interest in maintaining the integrity of the courts outweighs the defendant's liberty to disrupt a trial via her own misconduct.
Of course, at least as I understand it, Mr. Clayton, that's the general principle, that there are exceptions to it. At least my understanding of Mr. Orsman's argument is that he's continuing that this is one of those exceptive cases. Are you understanding it differently than I am?
Yes, Your Honor. I believe the precedent in both Supreme Court cases and the cases of this court are that if there is a substantial issue or substantial evidence, I should say, that gives rise to a concern, a bona fide doubt as to defendant's competency, then, at that point, competency hearing or other further inquiry would need to take place, which would be such exception to sort of that general rule.
I mean, let's assume hypothetically that a sufficient showing to necessitate a competency hearing had been made. And I understand you say that there wasn't, but let's assume that there was. Other than that, facts are the same. The trial court says no competency hearing. We're going to go forward with the trial if the defendant voluntarily chose to absent herself, therefore the rule about personal presence doesn't apply. I'm going to ask you the same question I asked Mr. Osborne. Is this case essentially hinged solely on the competency issue? Because if there's grounds, essentially if there's grounds to question the competency that were not investigated, then that would preclude the trial court from proceeding without further inquiry into the mental state of the defendant, and therefore there would be a legitimate basis for her absence. But the two questions are really about the same. Is that wrong?
Your Honor, absolutely. If there is a question, if there is sufficient evidence, given the specific facts of each case, and each case in this context is indeed very fact specific. But if there was sufficient evidence to give rise to a bona fide doubt, then the court would indeed need to undertake further inquiry to determine whether the trial proceeding should be suspended and a competency determination or a competency evaluation undertaken at that time. Based on the facts of this case, that was not necessary. The defendant waived, in fact, her statutory and constitutional right to be present for a duration of the trial and all of the privileges that come with it by undertaking this controllable voluntary act for the stated purpose of, quote, avoiding having to go to jail.
Mr. Clayton, I think the defense point in the Court of Appeals was that it's almost a chicken-egg issue. How can you say that they voluntarily chose to absent herself from trial without knowing first that she was competent to make such a voluntary decision?
Well, I think that the rule that defendant is relying on in Drobe is actually, that's not exactly what Drobe says. Drobe does not require a competency hearing prior to any making a waiver that a defendant voluntarily absented herself from trial. Drobe articulates no such bright line rule because, of course, every case is fact dependent.
But to Justice Davis's point, if the defendant is incompetent, how can you have a valid waiver of the right to be present?
Well, I think when you look at this case, the waiver, there was no evidence whatsoever in this case that the defendant was not competent prior to the act of, undertaking the overdose to avoid the consequences of her trial. After the third day of trial, after the state had essentially completed its entire case in chief, when a conviction likely appeared imminent, this particular defendant undertook a volitional act by, telling her children and medical personnel that I'm not going to go to jail. And so whether evidence of that, let me back up. That decision, based on all of the evidence before the court at that time, indicating that there was no reason to assume that this defendant was anything less than competent to stand trial.
Let me jump in here and ask you about how, if at all, does the magistrate's determination that she needed to be voluntarily committed and the medical opinion underlying that figure into your analysis of whether there's a need for further inquiry into her competence?
So, one, the state would argue, and the state contends strongly, that there was a further inquiry undertaken, but both the trial court and defendant in her own brief freely acknowledged that those involuntary commitment forms and the affidavit and the examination report form are quote unquote bare bones documents. Those are form documents that are basically sort of check the box that might have one or two sentences of actual sort of text. And thus, that's precisely the reason why the trial court did stop the proceedings and order the medical records from the hospital, CHS, as I refer to it in the brief, to get additional information. And of course, what that hospital provided were 89 pages, including narrative portions, dealing, with statements that she made to personnel while she was there as to what motivated her overdose. And so to sort of compare the two and to conclude that defendant was mentally ill based on, again, sort of boilerplate procedural documents after a defendant allegedly attempted suicide, the weight that you give to that, I think should be offset significantly by the weight that you give to the actual medical records, the more thorough medical records that were produced.
Well,
That's exactly.
Shouldn't the trial court have been determining at that phase not the weighing of the evidence, but just whether there was sufficient evidence to give rise to a question such that there should be a hearing?
I think perhaps, Your Honor. I mean, to the earlier question, the initial determination is to make sure whether the defendant has the ability to proceed, not whether she does or does not actually understand, the proceedings.
I mean, I guess my question is, if the magistrate's determination is a form document that's, as you say, quote, bare bones, and then additional medical records were obtained and received by the trial court that, indicate she continues to have a problem and needs more treatment. Why isn't that enough to meet the threshold of requiring a hearing into her competence under the statute, which looks like it sets a fairly low bar?
Sure. So, well, for one, I disagree with defendant's representation that, Badgett states that there can be no balancing of evidence of incompetence versus evidence of competence unless there's been an evaluation and a hearing. That's not what Badgett said, and that is not consistent with the facts in that case. Here, I think the trial judge, being in the best position to determine based on the context and the circumstances of the trial, is in the best position to determine what to make of what those records say. And those records do indicate that defendant suffered from advanced depression, or increasing depression, mood disorder, unspecified anxiety, but there was no indication of those medical records of prior inpatient psychiatric treatment, prior outpatient psychiatric treatment, no prior history of suicide attempts, no medication other than daily prescriptions from her primary care physician. And I submit that there's really nothing remarkable about that. Defendant, again, if you look at those records, and the trial court did before it made its ruling as to her voluntary absence, recognized that there were at least two instances in those records where it was clear that defendant had a rational and factual understanding of the proceedings, the nature and the object of the proceedings against her. She knew that she was on trial for embezzlement. She knew approximately how much she had actually taken over 7 years. She indicated that she had taken $50,000 up to $300,000 during that time. She indicated that Randy had been good to her, and she knew that she was on trial for embezzlement. That's clear from those records. It's also clear from those records that she, I think, facing an imminent conviction, made a decision that she was not going to go to jail. And, you don't have to guess about that. That's in those medical records.
Well, the statute only requires that when the capacity of the defendant to proceed is questioned, the court shall hold a hearing. And I guess my question is, why isn't the magistrate's determination that she had to be involuntarily committed, followed by the later medical reports indicating that she remains suicidal and is not safe for treatment in the community? Why doesn't that raise a question?
Well, I think it does raise a question, but again, when you put that circumstance in the context of the entirety of the trial proceedings and the entirety of the record on appeal in this case, you do have to sort of balance that. I mean, with regard to the statutory proceeding in particular, following this court's decision in State v. King, a trial court's question to a defendant's counsel as to a potential concern about that defendant's competency does not trigger the requirement that the court initiate a sua sponte hearing on its own. That's clear in King, which the facts of which are quite similar here. There, you had a defendant who indicated that or defendant's counsel who indicated that his client had a history of mental illness and depression, had previously committed suicide, had been treated for that. And the trial court specifically directly asked counsel, if there's some question about her his competency, I want to hear about it. But thereafter, the defendant's counsel or the defendant did not actually raise the question. And so
didn't the trial
this
court go
court
a
held,
little farther here? Didn't the trial court go a little farther and actually recess the trial and order that certain medical records be produced?
absolutely, Your Honor. I mean, here, yes, the trial court excused the jury for the first half of the day upon learning of her overdose, did the research necessary, research case law, drafted an order, I might add, that defendant's counsel actively participated in drafting, and who are stated to the court that he believed that that order was quote unquote rather complete. But not only did they recess the proceedings over a holiday weekend, over a long weekend, they got those.
My point being, the trial court here went much farther than the trial court did in King. And I'm going back to Justice Hudson's question, how high is the bar once the trial court has taken all these steps and is obviously concerned about the possibility that she's incompetent? How much more is necessary before the requirement to actually hold a competency hearing is triggered?
Well, I mean, I'm not sure that the trial court, after reviewing those records, assuming the trial court had, a concern as you described on Thursday morning when it learned of what had happened on the eve of the fourth day of trial. Once it, undertook to suspend the proceedings and get the additional records, it undertook that further inquiry that didn't happen in Drope and other cases cited by defendant. It undertook that inquiry, and based on that inquiry, it became clear that not only was there insufficient evidence in those records to give rise to a bona fide doubt as to the defendant's capacity to stand trial, it was also clear that this was a voluntary undertaking that was specifically, intended and calculated to disrupt the trial proceedings. And so, the court did go further, but in obtaining the information that it obtained and reviewing the information that it obtained, the state believes strongly that the court came to the correct conclusion and said, before we even get to whether or not this defendant has shown any manifestations of mental illness, which it obviously concluded that she hadn't, we need to determine, whether this particular defendant basically trying to take advantage of her own wrong and, buy herself more time and manipulate these court proceedings in bad faith.
So I want to make sure I'm understanding your answer to Justice Davis's question. As I understand, you're saying that the trial court went further here than they did in King and suspended the proceedings and got additional medical records, but based on that, then should have determined that she was competent, or I'm not sure. You're saying that was the equivalent of a hearing, or that those additional steps don't indicate that a question was raised requiring a hearing under the statute?
Well, I think I understand your question. It doesn't necessarily.
Feel free to say if you don't. I can try to make it.
Well, I'm trying to make sure that I'm not misunderstanding your question. So I'll take a run at it. And please let me know. But here, obviously the defendant's overdose sort of raises a question. The state's not taking the position that it doesn't. But to argue as defendant has, that by merely asking the question of defendant, whether he had observed anything prior to this overdose that would lead him to, have a concern as to defendant's competency, defendant characterizes that as the court's, as a reflection of the court's belief that the defendant was actually incompetent. And I think to state that by merely asking the question and the way that it did, kind of presumes that, perhaps she wasn't incompetent, that equates to a definitive determination on behalf of the court that it believed that the defendant was incompetent, is an interesting read of the transcript. I mean, the court was merely inquiring of defendant's counsel to inform its decision based on sort of the totality of the circumstances here, whether this was a manifestation of mental illness or whether this was a volitional act undertaken to, avoid the consequences of the trial.
Well, I guess my question is more, you've said a couple times that her overdose did raise a question, and the statute says that when the capacity of the defendant to proceed is questioned, so it doesn't require that the court say that the totality of the circumstances and evidence doesn't show that she's incompetent. There's just that when her competency is questioned, and I think I'm hearing you say that even though there was a question raised here, it wasn't enough of a question. Is that the state's position?
If I may, I'm sorry. Let me try that again. I think whether a question is raised by the trial court, at least following this court's precedent in King and Badgett and Young as well, if that question is not raised, I mean, if the trial court merely sort of acknowledges that there may be a potential competency issue and raises that question with trial counsel, and at least under our precedent, that's not enough to trigger the operation of the statute. Okay, and in this case, despite the fact that defendant had overdosed, defendant's own counsel never felt compelled to ask for a competency hearing or even object to proceeding without one. And so I think under the precedent of this court, that issue has been addressed by King in particular as to whether that triggers that low bar to, make the sua sponte hearing sort of a requirement. I think that what really happened in King and the other cases is that instead of sort of analyzing a situation such as the one you're discussing under the rubric of the statute, at that point, the court's analysis really turns to the due process issue and the whether or not a sua sponte hearing requirement has been triggered based on the evidence that's before the court. So even if the court has a concern, if the defendant doesn't raise it, it's waived. The defendant here didn't raise it, so it's been waived. And then the analysis switches really from the statutory evaluation to the constitutional sort of lens through which this issue is viewed. I mean, that's the way I read King, Badgett, Young, and all of the cases that have sort of dealt with the statutory requirement and whether or not it was triggered based on the court's action and the defendant's counsel's action. And so when you take it to the due process analysis, then you're looking at, sufficient evidence to raise a bona fide doubt. And, bona fide doubt isn't the mere possibility that a defendant, may be incompetent. Reasonable bona fide doubt is a reasonable doubt that I think when looking at the entire context and circumstances of the entire case, entire record in the case of an appeal, would lead a reasonable person to conclude that the defendant truly does not understand the nature and the object of the proceedings against her, such as how and why they're on trial and the consequences that might result, and that they cannot effectively interact with their counsel in navigating those proceedings. And that's just not what happened here. And that's evident not only from the CHS medical records, but from the first 3 days of trial that, proceeded without incident, the absence of any concern prior to trial about defendant's competency, the absence of any testimony during trial that would implicate defendant's competency. I mean, here again, that's what distinguishes this case from Drope and other cases that the defendant has relied on. And notwithstanding the fact the defendant says the factual distinctions between this case and Drope and other cases that she has relied on are irrelevant. I mean, given the fact that every one of these cases is fact specific and that there is no bright line rule, I think it's a grievous mistake, to represent to this court that the factual distinctions between this case and Drope and other cases that have found that there was sufficient evidence to raise a bona fide doubt existed. I mean, any meaningful comparison of those two cases, or any case between sides and some other case that holds that the bona fide evidence existed, has to be evaluated and compared on a factual basis. And so,
with your argument, it seems one could say is that here the trial court expressed a bona fide doubt. In other words, we're not asking, should the trial court have suspended the trial? Should the trial court have ordered the records be produced? The trial court did all this. And once the trial court did that, I think one could argue that the trial court reached the point of no return where he had no choice but to go ahead and have a full competency hearing. And it seems like at times your argument is conflating with really two separate inquiries. One is there a need for a competency hearing? And the other being, is the defendant in fact competent? But we're not at the second one, we're at the first one.
well, I think what determines whether there's a need for a competency hearing is evidence apart from the suicide attempt standing alone. I mean, that's clear from Drope.
Let me ask it this way. Can you cite to any case from our court where a trial court has taken the steps this trial court did, suspending the trial, calling a recess for several days, ordering that records of the defendant's mental health be produced, in which our court has said those steps did not trigger the need for a competency hearing?
As I sit here before you, Your Honor, no case comes to mind. But I think that it is inconsistent with precedent of the United States Supreme Court, this court, and the North Carolina Court of Appeals, nonetheless, to have a court, take those actions and obtain those records, and then essentially ask the court to ignore what the records reveal. And, whether this is an issue that has been litigated and brought before this court or not, I can't say. I honestly don't think it has. I may be mistaken about that. But that does not, I don't think, provide legal rationale to essentially espouse a position that says, even though the court, frankly, did what was prudent in this case, stop the trial, look at case law. Case law suggests maybe further inquiry would be appropriate, undertake that inquiry, and then after reviewing that information, make a decision. And it's not so much a conflation of whether she was competent versus whether it was voluntary. It's after looking at that information and all that it reveals, is there enough information in those records? Because there is information in the records that state, what the motivation was. And that motivation is not legally justified. It's not legal to overdose to escape the consequences of your trial. That's not a rational reaction. It's not a legal reaction. But in any event, if those records reveal additionally that, while there may be some potential for concern as to defendant's mental health, in keeping with precedent that's been, governing this space for almost a half a century or more, you must look at whether that information gives rise to a bona fide doubt that would lead the court to actually question whether the defendant was competent.
But it's not. I'm sorry. Go ahead, please. I'm sorry.
Oh, thank you. I just wanted to ask about distinguishing Drope, because certainly our precedents also say that the question of competency can arise at any point during the trial. So even though there was no reason to basis to question her competency at the beginning of the trial, subsequent events can give rise to a need to question competency, correct?
That is correct.
And so in Drope, you emphasize the difference in the medical history of the two defendants. But at the time of the actual incident in Drope, correct me if I'm wrong, but the defendant, who also attempted suicide unsuccessfully, he was not involuntarily committed. And unlike this case, where while there was an involuntary commitment based on the evaluation of a doctor, which included evidence that she was having hallucinations, and including a need to prescribe some pretty heavy medications for her. So doesn't that actually in some ways make this a stronger case than Drope? And what wouldn't we be bound by that?
I mean, let me just ask you this. Can you repeat that question? Because I want to make sure I'm answering this correctly.
Sure.
Because I'm not sure I agree, but I want to make sure.
Well,
sorry.
understanding that our focus should be on the time of the incident, because competency or being no longer competent can arise during a trial. That if you look at the evidence before the two courts in Drope versus this case, here there was a medical determination that she should be involuntarily committed. That was not a foregone conclusion. The doctor could have examined her and said, no, you're not, we don't need to commit you to protect yourself. But in Drope, that didn't happen. The defendant was not involuntarily committed.
Right. Thank you for that. I apologize. But I think in Drope, first of all, while the defendant wasn't legally involuntarily committed, I think the Drope court characterized his absence as an enforced absence from a self-inflicted gunshot wound. But, you know, speaking to this involuntary commitment piece, I mean, I think the dissent, for example, raises this issue that, at least from the dissenting justice perspective, the involuntary commitment in and of itself was sufficient evidence to give rise to a bona fide doubt. And that's just not the law. I mean, that's at odds with, you know, this requirement that every case is fact specific, that there are no bright line rules, like an involuntarily commitment in and of itself is evidence of incompetence. I think it's just at odds with what actually took place in this case. I mean, there was no evidence pre-trial that would suggest that this particular defendant was suffering from any type of mental illness, you know, whatsoever. The fact that she was involuntarily committed after undertaking a voluntary act, admittedly, you know, undertaken to avoid the consequences of her trial, yes, for her own protection, she was involuntarily committed. But I think the fact that she was involuntarily committed as a direct consequence and a direct result of that voluntary undertaking does not resolve the question. The fact that she was involuntarily committed after voluntarily waiving the right under Diaz is sort of there's very little weight should be given to that, because I mean, had she not overdosed, she would have been available for the duration of her trial proceedings and been able to testify and so on and so forth. However, on that note, even if she were able to testify.
Mr. Clayton, your time is up, sir.
Thank you, Your Honor.
Thank you. Mr. Osman, rebuttal.
Thank you. I understand that I only have a couple of minutes, so I'd like to point to a couple of things in the record, just to clarify. Quickly, if you look at page 413 in the transcript, there's obviously the state and this sides disagree about whether the statute was triggered and whether there was a request for a hearing. If you look at page 413, that's where I believe the defense counsel requested a hearing. It's a leap for us as lay people. It's the straw that broke the camel's back. There's a distinction between ending your life and trying to end your trial. We haven't had an investigation into whether she chooses or would like to be here, and I think that that's enough to trigger the statute. The next thing I want to point out, it deals with the due process competency question. And if you look at page 21 in the court's exhibit 3, the medical records, if you look at page 21, the examining doctor conducted a Columbia protocol. For those of you pulling up your mental file, that's the suicide risk assessment. And the medical examiner, right, and it gauges the severity of the risk and the immediacy of the risk. And the examining doctor assessed her risk level as high, right? This was not a competent defendant trying to take advantage of her wrongdoing, right? The person with the most skill and training and experience thought that assessed her risk assessment of suicide as high, right? He could have said she was malingering. The doctor didn't, right? The exact opposite. And then I see I've only got about a minute left. And so here's my elevator pitch, right? And I think we talked about this quite a bit. This case is just like Trope in every material respect, right? In both cases, the defendant attempted suicide during trial. In both cases, they said they committed suicide or were attempting suicide to avoid jail. Both defendants said that. In both cases, the trial court was confronted with medical evidence saying that they were mentally ill and needed inpatient treatment. Right? The state's argument is that this case is transformed into a right to be present case because the weapon of choice in Trope was a gun, and the weapon of choice in this case was a bottle of pills. That's what it turns on for the state. The Constitution is not fooled by such superficial distinctions.
Mr. Orsman, your time is up. Thank you. Thank you to all counsel. Madam Clerk, please recess us.
Thank you.
Oh yes, oh yes, oh yes. The Supreme Court of North Carolina will be in recess for 15 minutes. God save the state and this honorable court.